Namaste. A very good afternoon to you all. I thank the organizers for giving me the opportunity to be here on this important occasion and to share my thoughts and views with you with regard to a very important fundamental right under the Constitution of India, the right to profess, practice, and propagate religion. I am particularly grateful because this visit also gives me the opportunity to have darshan of Lord Balaji. So I'm very happy to be here. I will try to keep my talk as short as possible. In the short time which has been allocated, it is not possible to discuss all the laws which are there. But we all know that our country, India, has a people-centric, idealistic, democratic constitution. The Constitution of India is the foundation on which the entire structure of the Indian polity rests. The opening words of the Constitution begin with the words, "We the people of India." The people of India, acting through their representatives in the Constituent Assembly, enacted, adopted, and gave to themselves a constitution which promises to secure to all its people justice, social, economic, and political. Liberty of thought, expression, belief, faith, and worship. Complete liberty of faith and worship is a promise of the Constitution to the people of India. Then equality of status and of opportunity, and to promote amongst all dignity of the individual and the unity and integrity of the nation. Under our Constitution, India is a sovereign, socialist, secular, democratic republic. Of course, some people say, and rightly it is a fact, that the words socialist and secular were introduced by the 42nd Amendment Act with effect from 1973. Similarly, along with unity and integrity of India was added. But the Constitution of India has always been a secular constitution. And this is evident from the promise to secure liberty of faith, belief, worship. The preamble is now, after the Keshavananda Bharati case, considered to be an essential part of the Constitution of India. And the principles in the preamble constitute the basic features of the Constitution of India, which cannot be altered, which cannot be taken away. What is promised in the preamble has been conferred by way of rights in Part 3 of the Constitution of India, which is a chapter on the fundamental rights. We have Articles 25, 26, 27, and 28 of the Constitution of India, which are very valuable provisions in the Constitution of India. We all know how important religion is to most of us. But what exactly is religion? Religion is not defined anywhere in the Constitution. Religion is a set of beliefs, faith, which is inherent in a denomination or a group of people. And here in India, we have a huge population comprising people of different religions, different castes, creed, people who speak different languages, who belong to different areas in the country. And the religious practices also vary from place to place, from a group of people, a community to community. Religion, certain religious practices may be performed in Bengal in one way. It may be performed in Madhya Pradesh or in South India in some other way. But our religion, Hindu religion, is broad enough to take into fold all the different kinds of religious practices which are followed amongst different sects. Article 25 of the Constitution of India reads, subject to public order, morality and health, and to the provisions of this part, which is Part 3 of the Constitution of India, which contains the various other fundamental rights. All persons are equally entitled to freedom of religion, freedom of conscience, and the right freely to profess, practice, and propagate religion. However, this right is not absolute. There are restrictions. This right is subject to public order, morality, and health. So, if and when there is any interference from the state, it has to be in the interest of public order, morality, and health. Sub-article 2 clarifies, nothing in this article shall affect the operation of any existing law or prevent the state from making any law. The state has the power to make laws. But what laws? Laws regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, the law can at best see that the funds of a temple are not misappropriated, they are not misutilized, that in the name of management, a temple is not mismanaged. But it is very clear that the restriction has to be with regard to economic, financial, political, or other secular activity, and not any religious activity. The right to propagate religion, the right to profess, practice, and propagate religion doesn't only mean belonging to a religion, having faith, and having certain beliefs. It includes the right to give expression to that belief, that faith. So the right to profess, preach, practice religion includes the right to carry out essential rituals and rites which are connected with the particular temple. And there can be no interference from anywhere with regard to such right, except in extreme cases where it is absolutely necessary. Say, for example, human sacrifice can never be allowed in the name of religion. So there can be most certainly be a bar to such practices. Similarly, the fundamental right under Article 25 and 26 are subject to the other fundamental rights in the Constitution of India, which includes abolition of untouchability, which is also a fundamental right. Therefore, laws have been passed opening access, allowing access of people, of all persons who are Hindus, to a Hindu temple, irrespective of caste. But this right to enter a temple, to visit a temple, does not give any member of the public who is a Hindu to perform worship in his own way. That worship has to be done in accordance with the tradition of the temple, according to the wishes of the founder of the temple, in the manner in which this has been going on. Now, Article 25 is very clear. It clearly distinguishes between religious practices and secular activities associated with religious institutions. The state has the authority to regulate or restrict secular activities that may be associated with the religious activities, but not with rituals which are an essential part of the religion. In the case of Vaishno Devi Shrine Board versus State of Jammu and Kashmir, the validity of Jammu and Kashmir Mata Vaishno Devi Shrine Act was challenged, but the court found that the act was made for better management and governance of the temple. In that case, the Supreme Court had held that the service of a priest is a secular activity and it can be regulated by the state under Clause 2 of Article 25. However, the removal of a priest or the replacement of a priest is an extreme step which is not ordinarily taken, and when it is taken, it has to be ensured that the person who is being appointed, the person who is being replaced, has the necessary qualifications and competence, the necessary eligibility to be appointed priest. Article 26 of the Constitution of India provides that subject to public order, morality, and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. This is a fundamental right of a religious denomination. It has the right to manage its own affairs in the matters of religion. Religion means essential religious practices. To own and acquire movable and immovable property, and to administer such property in accordance with law. We also have Articles 27 and 28. Article 27 prohibits taxation to promote any particular religion, and Article 28 prohibits an institution running out of state funds or an institution recognized by the state from compelling any minor student to take religious instructions without permission from his parents. In other words, that article was a protection for persons like us. I happen to have studied in a Christian missionary school, a Catholic missionary school, but by virtue of this provision of the Constitution of India, we were completely exempted from any classes on Bible history, and similarly we were exempted from going to the chapel. If we went on our own wish, then that was a different issue altogether. It is important to remember that the protection guaranteed under Article 25 and 26 is not confined to only matters of doctrine or belief, but it extends to acts done in pursuance of religion, and therefore contains a guarantee for rituals, observances, ceremonies, and modes of worship which are essential part of religion. This was reiterated by the Supreme Court in several judgments. I can refer to Commissioner of Police versus Acharya Jagadishwarananda Avaduta, judgment of the year 2004. Now, why am I referring to what the Supreme Court has held? That is because the Supreme Court is considered to be the guardian of the Constitution of India. It protects constitutional rights, and it interprets the Constitution of India. The High Courts also interpret the Constitution of India, but the Supreme Court happens to be the final court. And under Article 141 of the Constitution of India, the law, including the Constitution as interpreted by the Supreme Court, has to be followed by all courts, lower courts, tribunals, etc. The right is not confined to citizens alone, but anyone residing in India. The right to profess, practice, and propagate religion, subject to restrictions. These restrictions may be imposed, one, on the ground of public order, two, on the ground of morality and health, three, on the ground of other provisions of the Constitution of India, and the restrictions have to be restricted to the non-religious activities associated with the temple. It is also important to remember that under our Constitution of India, the freedom of one cannot encroach into the freedom of religion of another. So we have to respect everyone else's religion. The right to practice religion would include the right to take out processions. And there may be music in the processions. In Calcutta, I have seen ladies visiting the temple on particular days and then walking down the streets of the neighborhood singing bhajans. That is perfectly permissible, and nobody can stop it, saying that it is irritating. But at the same time, just as music is permissible, you can't play loud music violating the noise pollution laws at the middle of the night. That is why restrictions which had been placed by the Supreme Court for bursting of crackers during Diwali between 10 p.m. to 6 a.m. in the morning was upheld, because such noise, loud noise can cause difficulty to the elderly, to students who may be studying for examinations, and to little children, to infants who may need their sleep. Apart from practicing rituals, apart from taking out processions, organizing bhajans, the right to religion also includes the right to propagate one's religion. So the pravachans which are held in the temple precincts is perfectly permissible. Nobody can object to it because it is up to a person to decide whether he wants to go and attend the pravachan or not attend the pravachan. But that cannot be stopped. Similarly, there are some other practices. I am not aware of all of them, but some are very common practices. Say, the early morning prayers. In the Lord Balaji temple, you have the Suprabhatam, the prayers which are done when the Lord rises, when he is waken up. You have the abhisheks, you have the aratis, you have the offering of prasad, offering of bhog in other temples during the daytime. These are practices with which there can be no interference because they are very essentially a part of religion. When I talk today, I'm confining the rights because this is a temple convention and temples are of Hindus. There may be similar rights provided under the Constitution to people of the Christian community, the Mohammedan community, etc., because the right is available to all as per their own customs. But I am confining myself only to temples, otherwise this would be very long. But what the government can do is to ensure that the laws relating to purity of food products, that the food adulteration laws are complied with. For that, it may be possible for the government to take sample in a manner which does not affect the essential religious practices and to have it tested to ensure whether there has been any kind of adulteration. There was a law, one of these religious and charitable endowments laws. It was a law of the Madras Presidency which permitted entry into the sanctum at any time to test or to check whether there was any violation of law. That was struck down as violative of Article 25. Inspection is permitted even today, but notice will have to be given. People can't walk in wearing shoes. All the rituals and customs would have to be followed when such inspection is done in the interest of law. Freedom of conscience also contains the right not to be converted. So any law which provides for forcible conversion of a person against the wishes of the person, of course voluntary conversion may be protected under Article 25, but getting people to convert is a punishable offense. When we exercise our freedom of religion, it is open for the state to ensure that we do not outrage the religious feelings of another class with deliberate intent. Deliberate is the word used. So, if a person is too sensitive to a mere chanting of bhajans or to a mere religious practice, then that would not be countenanced. Ban on noise emitted from firecrackers has been upheld by the courts. Courts have held that the mere guarding of a shrine by policemen does not violate the right to practice religion, because this is done to ensure that there is no breach of law and order. Similarly, the state may ensure that the right to propagate religion, when it involves speech, when you give a speech to propagate religion, you are governed by the restrictions in Article 19, between Article 19's 2 to 6, relating to the rights under Article 19. Particularly the restriction with regard to freedom of speech, which permits restrictions in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement of office. But with regard to contempt of court, let me tell you, any criticism of a court order, a legitimate criticism of a court order does not constitute contempt. It is an overt act or a statement which lowers the dignity or majesty of the court. A defamatory statement, not a mere discussion of a judgment. So if a person says that I do not think the judge was right, or if he says that the judge has passed this order overlooking an earlier order passed by a bench of coordinate strength, or has not considered an earlier order, that does not constitute contempt. But what you cannot do is that under the garb of a speech to propagate religion. You cannot denigrate the judiciary. You cannot defame others. You cannot say things which will affect the security of the country, the sovereignty of the country, etc. As I started off at the inception, the right is available to everyone, irrespective of whether the person is a citizen of India or not. Now, who can complain of infringement when it comes to interference with the temple? The head of the religious institution can. The head of the religious institution can even approach court. But then again, the courts have held that there is no infringement by appointment of an administrator pending inquiry against a Mat Adhipati on charges of misappropriation. However, displacing the management is an extreme step, and it is taken only where there is mismanagement, where there is misappropriation, where there is diversion of funds, where a temple is not run in the manner in which it was expected and in which it was supposed to run. Now, we've been talking about essential religious practices. What are essential religious practices? Who is going to decide what are essential religious practices? It is people who belong to that religious denomination who decide. It is the people who run the temple who decide. But when there is a dispute, you obviously approach court, and then the court has to decide, taking note of the evidence which is available to decide whether a practice is an essential religious practice or not. Say, for example, in the case of the triple talaq case relating to Mohammedans, the Supreme Court held that triple talaq was not essential to the practice of Islam, and accordingly struck the practice down as unconstitutional. Similarly, after the Hindu Marriage Act had been enacted, there were challenges on the ground that it sought to prohibit bigamy or polygamy amongst the Hindus. It was also urged in court that a second marriage or a third marriage might be necessary for having male heirs to continue the legacy, including religious practices. But there the Supreme Court upheld the law, saying that marrying more than one wife was not an essential religious practice, and that the problem of heirs could be sorted out by adoption, which was permitted under Hindu law.